First, stockbroking company and client. The basic legal relationship that exists between a stockbroking company and client is that of principal and agent. A stockbroking company that is instructed by a client to buy or to sell security on a stock market is an agent of the client, and the normal rules of the law of agency apply to the relationship between them. For participating organization, it can be defined as a company which carries on the business of dealing in security, and for the time being recognized as a participating organizations of the exchange pursuant to the rules of the exchange. However, remissier is an agent of the participating organization to trade in security in the name of participating organization. Both of the participating organization and remissiers have its own duty and obligation. Participating organization takes all relevant and reasonable action against client for the recovery of indebtedness, which should be reimbursed to the remissier in the event that the remissier's security deposit has been utilized towards that indebtedness. Besides, it disseminates copies of all directives, circulars, and information relevant to the remissier in respect of the conduct of the remissier's trading transaction. On the other hand, remissiers are responsible for any losses which may be incurred by the participating organization arising from any transaction in security dealt by or through him. They take into account the client investment objective, knowledge, and experience in dealing in security, as well as the particular needs of the client. Secondly, rules governing the stockbroking company and client relationship. There are three sources of rule governing the relationship between stockbroking company and client, which include the General Law of Principal and Agent, Capital Market and Services Act 2007 (CMSA), and the rules of Bursa Malaysia Security Berhad. In General Law of Principal and Agent, a contract of agency is formed when one person, the agent, has the authority to act on behalf of another person, the principal. Client is the principal, while the stockbroking company acts as the agent. The client authorizes the stockbroking company to buy or to sell the share, and the stockbroking company is paid with a commission or brokerage by the principal. For the term of instruction, it is given by a client to a stockbroking company, and therefore the terms of contract may be expressed or implied. Express instructions are the instructions that given orally by the client to the stockbroking company, while implied instruction usually goes without saying, as the inclusions of the client is so obvious. The next sources will be the Capital Market and Services Act 2007 (CMSA). The CMSA regulates the conduct of people engaged in the capital market through Section 91, Section 92, and Section 97. Section 91 provides that a licensed person must inform its client of any interest which may influence its recommendation to the client. Section 92 sets out the specific requirements which must be followed when a licensed person provides recommendation to a client. And Section 97 provides that a CMSRL holder who carries on the business of dealing in security must inform the client when it is acting as principal in the transaction with the client. For the last sources, it will be the rules of Bursa Malaysia Security Berhad. It set out procedure and obligation of participants of the stock exchange in trading and dealing with each other and their clients. It is binding on participants, as they can be suspended or expelled if they do not comply with the rules. In addition, it stipulates that for trading purposes, participating organizations are deemed to be contracting as principal with each other, and the contracts are inviolable. According to Section 354 of CMSA provided that the rules of Bursa Malaysia Security Berhad can be enforced by security commissions against any person who is under an obligation to comply, observe, or give effect to them. This gives the rules of Bursa Malaysia Security Berhad greater importance as a source of law governing the relationship between participating organizations and client.
I will explaining about the buying security on the market. We will discuss about the practices during stock exchange transactions. Firstly, the person have to open a trading account, and then the person can buy or sell shares through licensed dealer representative. The person can then instruct the dealer to buy or sell on his or her behalf. The order are then made into applicant tracking system (ATS) and received by the participating organizations. The order are then automatically matched by the system. Then the contracts are made, and a trade confirmation consists of details such as order number, stock number, price, and quantity are then be sent to the client. Next, the dealer will confirm with the client that the shares had been bought or sold and inform the price. Then the participating organization sends the contract note consisting of the details needed such as the brokerage, stamp duty, and clearing fee payable, and also the cost of the purchase or the proceeds of the sales. The delivery and the settlement of the shares will be done according to the Bursa Malaysia Security Berhad Fixed Delivery and Settlement System (FDSS). Next, we're going to discuss about the contract note. Contract note is the legal record of any transaction carried out on a stock exchange through a stockbroker. It serves as the confirmations of trade done on a particular day on behalf of a client on a stock exchange. Rule 404.3 Clause 9 of the Rule of Bursa Malaysia Security Berhad states that all the contract note must contain the information according to the regulations made under S90 of the CMSA, and the name on the contract note must be the name of holder of security account as appearing in the record of depositor. Next is default. Common default is when either the seller fails to deliver the security or the buyer fails to pay for their security purchases. The deals between selling and buying parties are done according to the rules of Bursa Malaysia Security Berhad. Each participation organization has the right to indemnity against its respective client. Indemnity is the legal exemption from penalty incurred by one's actions. Default in meeting commitment by a participation's organization are liable to be excluded from stock exchange. Rule 803 and 805 of the Bursa Malaysia Security Berhad shows the measures to be taken against defaulting client. The clients are liable for the difference between the contract price and market price, including the losses or expenses when the client fails to complete the contract. The profit from resale and repurchase are given to the client. The participation organization under the Rule 601.6 of the Rule of Bursa Malaysia indicate they have lien on all securities held by it on account. Clients in default for a sum of 2,000 or more, the participation organization can report it to the Bursa Malaysia Security Berhad under the Rule of 403.1 subject to requirement in Schedule 5 are satisfied. And 4 is the direct business. Direct business transactions is defined as the transactions in security entered into outside of applicant tracking system (ATS), including such as the closing, which is defined as the direct business transaction report to the exchange between A. Two clients of different participating organizations, B. Two different participating organizations, or a participating organization and a client of another participating organizations. Arranged merit transactions, which mean a direct transaction reported to the exchange between two clients of the same participating organization or a participating organization and its client. Other transactions are determined by the Bursa Malaysia Security Berhad. Now we will look at the price range and the reporting requirement. Direct business transaction can be transacted at any price as agreed between the parties. If the price of the direct business transaction reported to the exchange falls between the price prescribed in Schedule 4, a participating organization must comply with the following: A. submit the following information to the exchange in writing by 12:30 p.m. on the next market day after direct business transaction was reported to the exchange, which need the detail of the buyer and seller, the number of security involved and the price, the basis on which the price of the direct business transaction was agreed, and the reason for the direct business transactions. B. Ensures that the client executes the declaration in the form as prescribed by the exchange. And C. Maintain the following document for at least 7 years. The document needed is the declaration executed by the client in the form as prescribed by the exchange, the written agreement evidencing the direct business transactions, and any other relevant document in relation to the informations. No direct business transaction can be reported under Rule 10.06 during first hour on the first day of the trading or listing of the following securities: security that has just been outlawed for our trading halt or suspensions, security that has been listed or quoted on the exchange, including security quoted pursuant to a corporate actions, and security quoted on an ex-entitlement basis. The participating organizations must comply with the obligation in Rule 10.09 Clause 2 for a direct business transaction transacted on the security mentioned in Rule 10.10 Clause 1 if the direct business transaction was transacted at the price stipulated in Schedule 5. In relation to a direct business transaction involving security which are imposed via a trading halt, reporting under Rule 10.06 and the VWAP to be used to discharge the obligation mentioned in Rule 10.10 Clause 2 are set in the table below.
Participating organizations' duties to clients. The Bursa Malaysia Securities Berhad sets out the requirements of best business practices in Rule 404 of the Rules of Bursa Malaysia Securities Berhad. Rule 404.1 Clause 3 states that participating organizations should not carry out acts which will adversely affect the goodwill or public image of Bursa Malaysia Securities Berhad, brings Bursa Malaysia Securities Berhad into disrepute, injuries to the character and interest or prejudicial to the objects of Bursa Malaysia Securities Berhad. 5.1 Obey instructions. Under Rule 404.3 Clause 6, it is stated that every participating organization shall ensure that its dealers' representatives carries out clients' instructions with proper skill, care, and diligence. Priorities in execution of orders are given to clients in the same sequence they are received. The participating organization shall not act on any instruction received from any person purporting to act on behalf of the client before obtaining written authorization from the client. 5.2 Make the best deal for client. A participating organization must make the best possible price for the client. For instance, purchase at a price lower than that stipulated by client, sell at a higher price than specified. 5.3 Issue contract note. Participating organizations must inform their clients regarding any transactions entered into on their behalf. After the completion of a sale or purchase of securities, the participating organization must deliver a contract note recording the essential details of the transactions to their clients. Requirements for the giving of and the form and content of contract notes are contained in Section 90 of the Capital Markets and Services Act and the regulations met under it. 5.4 Not to compete with client. A participating organization has a duty of good faith to a client to avoid potential or actual conflicts of duty and interest. As an agent, the participating organization should put the client's interests ahead of their own. Section 93 of the Capital Markets and Services Act requires a participating organization to give priority to a client's order for the purchase and sale of the particular securities over the purchase and sale of the same class of securities as a principal or on behalf of an associate. Such restrictions does not apply in cases where the participating organization is unable to execute the client's order due to price conditions imposed by the clients. Under Rule 404.3 Clause 10, it states that participating organization or its dealers' representatives are prohibited from entering into a transaction of their interest which may conflict with its duty to their clients. full disclosures must be made to the participating organization and client prior to the execution of a transaction whereby conflict cannot be avoided. 5.5. Inform the client when acting as a principal. Participating organization is prohibited from acting as a principal when meeting a client's order without informing and obtaining consent from the client beforehand. Clients has the right to repudiate the transaction upon discovery of the fact that it is done without their consent, although the participating organization have acted fairly and sold the shares at market price. Section 97 of the Capital Markets and Services Act specifically requires participating organization to disclose when it is acting as a principal. Note that participating organization must inform the client. Participating organization must state in the contract note that it is acting as a principal in the transaction, not as an agent. Client may rescind the contract by giving notice in writing within 14 days if disclosure is not met. Participating organization who send circulars to clients recommending particular securities must disclose their interest in those securities, if exist. Section 83 of the Capital Markets and Services Act requires participating organization to maintain a register of interest that they have in securities. 5.6. Participating organization employee and director share dealing restrictions. Rule 702.2 Clause 2 of the Rules of Bursa Malaysia Securities Berhad states that the employees of participating organization cannot transact in securities provided there is a written consent for the transaction from a director of the participating organization. Rule 702.3 states that directors of participating organization requires written consent from the board of directors of the participating organization before they can transact, and those transactions must be recorded in the Register of Securities kept under Section 83 of the Capital Markets and Services Act. Failure of employees and directors to disclose all transactions or obtain prior consent from the participating organization could result in suspension or fine or expulsion. 5.7. Due care and diligence. The participating organization should use due care, skill, and diligence in carrying out its duties. Rule 404.3 Clause 6. Every participating organization shall ensure that its dealers' representatives carry out clients' instructions with proper skill, care, and diligence. Priority of execution of orders is in the sequence in which they are received, regardless whether the client is an individual or institution. Section 92 of the Capital Markets and Services Act. Advice given must be based on clients' investment objectives, financial situation, and particular needs as far as the participating organization can ascertain. Participating organization that contravenes these requirements, although not guilty of an offence, but may be liable to pay damages for any loss suffered. Rule 404.3 Clause 3. Participating organization is required to implement and maintain guidelines assisting dealers' representatives in learning essential facts about their clients' backgrounds, including clients' investment objectives, knowledge and experience in dealing with securities, financial background, and other information required by Bursa Malaysia Securities Berhad. Rule 404.3 Clause 5. Participating or dealers' representatives are required to take into account and ensure suitability of recommended transactions for their clients, disclose the potential risks involved to clients, satisfy itself that the client has the financial capability to bear any risks attached to the recommended transactions. 5.8. Maintain separate client accounts. Participating organization must keep the client's property separate from its own and keep proper accounting records that enables identification of client's property. Money received by participating organization on behalf of clients must be paid into a designated trust account. Participating organization must have a clear written guidelines on the treatment of clients' money that comes into its possession.
Profit and loss accounts and balance sheet must be prepared and audited. 5.9 Conflicts of interest. If the participating organization is trading in competition with client, the participating organization must give the client's order priority. If the participating organization is trading as principal with the client, the participating organization must make sure full disclosure of the fact that it is acting as principal. If participating organization is underwriter of shares and also acts for clients who buy shares, the participating organization must disclose that it is acting as underwriter so that the clients are aware that advice may be biased. If participating organization owns shares and recommends these shares to clients but does not trade directly with them, the participating organization must disclose the nature of its shareholding to its clients so that they are aware that advice may be biased.
Next is 6.0 Participating Organizations' Rights. There are three rights, which are right to receive commission, right to indemnity, and right to lien. 6.1 Right to receive commission. A participating organization is entitled to be paid by the client for carrying out its duty. Brokerage rates are fixed and prescribed in the Rule 1001.1 Clause 4 Clause A under the rules of Bursa Malaysia Security Berhad. A participating organization acts for both buyer and seller, thus brokerage is payable for buying and selling. For each transaction on the stock exchange, there is a 0.015% levy that charged to the clients by the participating organization to be paid to the Bursa Malaysia Security Berhad for the account of SC. 6.2 Right to indemnity. A participating organization is entitled to an indemnity for any transaction entered into on the behalf of the clients. Therefore, the participating organization is legally protected against liability that may result from the transaction and can receive compensation from the client for any monetary loss incurred. Under Rule 805.4 of Rule of Bursa Malaysia Securities Berhad, the right of indemnity is recognized by giving a buying participating organization the power to resell securities if the client defaults in paying for them, as well as giving a selling participating organization the right to buy securities to sacrifice delivery obligations where the clients fail to deliver the share. 6.3 Right to lien. A participating organization is entitled to retain a client's security until it has received full payment from the client. The payment need not necessarily be directly related to the securities being held. Under the Rule 6.01.6 of the Rule of Bursa Malaysia Securities, when the clients are on money to the participating organizations, it permits the participating organization to deposit the client's share as a security for the loan. If it owns the participating organization any money in respect of purchase of securities until the amount owning are fully paid to the participating organization. 7.0 Clients' Rights. Clients has the right to file a written complaint against a participating organization or its dealer's representative in the respect of transaction in securities effected on Bursa Malaysia Security Berhad. It is the duty of every participating organization to establish and implement written procedure for handling of complaints from its clients. These are the type of complaints that can be done by the clients, which are complaints against public listed company, licensed intermediaries, share registrars, issuing houses, complaints against exchange, complaints against dealing in unit trust, dealing in securities, and dealings in future. There are two claims that can be done by the clients. First, claims for compensation funds. Bursa Malaysia Security Berhad is required to establish and maintain a compensation fund under Section 141 of the CMSA and Rule 1401 of Rules of Bursa Malaysia Security Berhad. Any person suffering a loss in the manner referred to in Section 152 of CMSA can be claimed from the compensation funds. The other claims is the claims to the Security Industry Dispute Resolution Center. Alternatively, the complainants may be eligible to seek the assistance of the Security Industry Dispute Resolution Center (SIDRES) if the complaint is regarding a monetary dispute not exceeding 100,000 ringgit Malaysia against a licensed intermediary. Security Industry Dispute Resolution Center is a body approved by the Security Commission to handle the monetary claims by the investor against stockbroker, future brokers, fund managers, and unit trust management companies, among others, who are licensed under CMSA to conduct regulated activities in Malaysia.
Keeping of records. Rules of Bursa Malaysia Securities Berhad provides that participating organisations must keep records of their transactions and that these records must comply with Section 10(8) of the Capital Markets and Services Act. Clients can ask participating organisations for copies of entries into the participating organisation books relating to transactions carried out on their behalf. Under Rule 404.4 Clause 2, participating organisation must, in respect of each client account, maintain records including date of opening the account, client's financial position, name of the officer which approved the opening of the account and date of approval, type of transaction for the approved account, details of all transactions including commission charge, type of transaction and current position of the account, dealer's representative handling the account.